How to make sure your loved ones are taken care of once you're gone.
Call, text, email, then join me along with the experts from Hollis, Wright, Sunday after the news at 10.
Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into the attorneys. We appreciate you spending part of your Sunday evening with us. For the next half hour, the plan is for you to get your tough legal questions answered by our panel of experts. For that to take place, you got to get those questions to us. You'll find throughout the half hour that the numbers, ways for you to get in touch with us will be displayed on the screen. You can call, text, email. In fact, attorneys are standing by to take those calls, texts, and emails. If they're busy, it'll go to a calling service, but they'll get back to you real soon. So go ahead and get those questions into us. Carter Clay with the firm of Hollis Wright is here to lead our discussion. Good to see you, sir.
Good to see you, David. It's great to be here with you.
Well, I'm glad you are, and you're kind of a newer member of the team, but looking forward to working with you, and welcome to the fun we have here on Sunday nights.
Well, thank you. I think we have a great show here tonight. We've got a topic that's not always the most exciting or stimulating topic to cover, but it's very important. You know, they say that there are only two certainties in life, death and taxes, and we're here tonight to talk about what happens when a loved one passes away, what should you do when that happens, and really what should you do before that happens to prepare for that inevitable event. Tonight we're very fortunate to have Jerry Templeton at the Templeton Group here with us. He is a longtime lawyer here in the Birmingham area, been practicing for quite some time. And he's here tonight to provide us with some very informative tips and advice on how to go about preparing for death of a loved one and to make sure that you have all of your bases covered. Jerry, if you could just introduce yourself and tell us a little bit about your practice as it relates to wills, trust, and estates and those types of issues.
Thank you. It's my pleasure to be here. I do practice in the area of estate planning. Everyone has a will in the state. They don't know it. Maybe it's the will that the state has drafted for you, or it's the will that you have drafted for yourself. I recommend drafting one for yourself, and we'll talk about that.
Yeah. How do I know, if you're a viewer and you're watching, how do you know if you need a will?
If you're over the age of 18, of sound mind, and want to declare what you want done with your property, you need to make a will. It's that simple. Right. There's no other thought process is really involved. It's not that complicated. It's not that time consuming to do. Most attorneys will meet with you and provide you with basic help and give you the fundamentals to lead you through that process.
Yeah. In your practice and your years of experience here, what are the most common misunderstandings about wills, estates, and trusts that you run into?
One would be that the process is expensive. I think a lot of attorneys will provide you with at least 1 hour of consultation and free to sit down and go through to look at your situation. That would be the first thing. If you are worried about making loved ones mad, or what you want to do with your property may not be what they want you to do with your property, those concerns really fall by the wayside when you understand the legal process and why you should do it. And you can in a will, you can pretty much direct how you want things to go. The state has little control once you take control of the situation.
Yeah.
Jerry, do you have to have a lawyer draft a will for you, or can you do it yourself?
You do not have to have a lawyer. As long as you meet the fundamental requirements, the will needs to be in writing. It needs to be signed in front of witnesses, notarized. Once you follow the proper process, you can do it yourself.
Are there any caveats or pitfalls that you could convey to our viewers about attempting to draft a will themselves, as opposed to perhaps getting a lawyer or some professional help in that regard?
You know, it can cost you money and time. If you don't know that you can waive certain requirements in a will, such as a requirement of a bond, the filing of inventory and accounting to the court, those type of things that if you know that you can do yourself, the lawyer will do for you. If you don't know, you won't do those things, and your estate process will be more time-consuming and expensive.
A couple of things I would certainly like to avoid. I mean, one of them is having the state assign my property, you know, and like you were saying, in terms of a will. But I oftentimes hear of bitter disputes once a loved one passes away over their property and their money. How can that be avoided? Because oftentimes it sounds like they have some form of a will, but there's just a lot of disagreement on it, and it really ruins and wrecks a lot of relationships and families.
It does occur. I don't think it is quite as often as people might imagine. So long as you have put in your will and it's valid and it's proper, you're of sound mind, you make good decisions, you declare what you want done. I don't think that the problems come into play. I see more problems when folks have failed to make a will. Right. Then you get into what we call the law of intestate succession, which is the state mandated procedure of what happens. It's just not the same. People look at it and they find out, oh wait, the state says I have to do this or that. It's a different process. If you go through the process and make your own will, determine what you want done with your property, those issues that you're referring to, I think, fall by the wayside. Those become less important because you've got your statement on record of what should happen.
Yeah. And what would you recommend to the viewers in terms of once they draft a will, whether they attempt to do it themselves or if they have an attorney do it for them, how many copies should be made? Where should the will be kept? Should the beneficiaries of the will be given an immediate copy? What kind of recommendations would you give to the viewers in that regard?
Well, you make one will at a time. That's the first thing. You can make copies and provide them to folks after the final will is made. I maintain wills for my clients. I recommend if I'm not going to maintain the original for them that I draft, that they provide a safe place to keep them. Not necessarily a safety deposit box, even though I think that is the knee-jerk response of most folks. There's problems in getting into safety deposit boxes. If you've got your will in a safety deposit box that no one knows about. So if you're going to put the will there, then there's additional safeguards that have to come into play as to making sure that someone knows where it is, that the folks who are listed in the will or who are the administrator or administratrix of the will would, those folks would know where to find the will. So wherever you put it somewhere safe, keep it dry. If it's been out there for a long time, check it. Make sure that it hasn't deteriorated. You'll find that wills are falling apart sometimes and people keep them in various places. I've seen a lot of different types come in. But that's a good point. If you're going to make one, make sure someone knows where to find it and keep it in a good condition.
How often do you need to update it?
That depends. That's a good legal answer. If your financial situation has changed dramatically, if you've remarried, if you've gotten a divorce, if there's birth of children, a lot of those things come into play. Just life experiences would come into play that would make you take another look at what you have in place and what needs to be revised.
Right. Okay. Go to a question we've got here. I was told that I cannot assign my property to whoever I wanted to by making a will. Is that true?
Well, for the most part, it's untrue. You can assign your property pretty much how you want to. If you are married, for instance, there is a limitation that you can't exclude a spouse. That would be a primary problem that would come into play. That's typically handled through the legal process of either post-nup or prenuptial agreements. You either make a plan with a new spouse to do something outside of the will before you're married or after you're married. So that type of situation would be handled through another instrument.
Right. All right. Time for our first break. As we head to break, a reminder to you, we'd love to get you involved in the conversation. Attorneys standing by to take your calls, texts, emails, so get in touch with us. Here's how you can do so. The number's there, the email as well. Find the firm of Hollis Wright on Facebook and Hollis_Wright to find them on Twitter. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, and thanks for watching the Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple. provide answers and legal counsel when you need it the most. Now, your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family, or simply contact us by going to alabamas13.com and click on the Attorneys link. Now, we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
Where to keep those wills, those important documents, often important to consider. Welcome back into The Attorneys. We got a few minutes, a couple of segments remaining, so still plenty of time for you to join the conversation. And we try to make it easy for you. You can call, text, email, get that information into us, and we'll be sure and do our best to pass it along if we have time to our panel of experts.
Jerry, one of the questions I always get from a lot of my clients is that they say, look, I don't have a lot of property, I don't have a lot of assets. Rather than spend money going to a lawyer crafting some real complex will, can I just handwrite the will myself and sign it? And if I do, is that legally enforceable?
Well, there's problems with that. A totally handwritten will that is signed by someone that's not notarized or witnessed by anybody else, that's called a holographic will. Those are not allowed in Alabama. Alabama would require that the will, if it is handwritten, that it is signed by the person, that there are statements made by the person that declaring that it is the last will and testament. Also, it needs to be witnessed, and really for probate process, it needs to be signed by the person making the will in front of a notary public at a bare minimum. A holographic will, handwritten in the person's own handwriting, that's not witnessed, not notarized, but just signed by the person, is not generally valid to state that person's last intent.
Okay. So it sounds like it would definitely be a good idea to comply with those requirements, have it witnessed, and do it in that proper fashion.
Absolutely. The courts will give leeway as to trying to discern intent, but without somebody else seeing that person sign the document, somebody else hearing that person say, this is my last will and testament, that can stand in front of the court and be a witness, the courts are generally not going to allow that document to stand on its own.
Do you see a lot of holographic wills in your practice where people attempt to just dispose of all of their property through that process?
Rarely.
Rarely, okay. So most people are following the proper procedures.
I think folks that do that will have someone either witness it. You'll see hand-signed, hand-drawn wills that are witnessed but are not notarized sometimes, but just someone writing down their last wishes and not telling anyone about it. It's rare that you see that.
Head to a question we've got here. I was left my mother's house in her will. Can I now sell the house now, or is there something else that I have to do before I can sell it?
Well, if the question is if the house is left in a will,
okay.
Well, the will would need to be probated first of all. So that was a formal opening of an estate administration with the probate court in the county where you live. Once that estate has been opened, then the person that's appointed to oversee the estate would have specific powers and duties that they would have to take with respect to real estate. Alabama, as everyone knows, when you go to your closing, you get a deed. Alabama, with real property, you own through your deed, and your ownership rights are all merged into that deed. So the specifics of the deed would also come into play as to what can be done with the property. If the decedent is the only owner of the property, then there would be a new deed and court order coming out of the estate administration to transfer that property, even though it is stated in the will.
Right. Okay. Another question here. I have 3 sisters. My oldest sister was named as personal representative after my mother died. The rest of us don't feel that she is doing her job as far as handling my mother's property. Can we have her removed?
The simple answer is yes. I think the question is presuming that an estate has been opened, there's an administration with a will or without, and in that administration that the court has appointed someone to overlook the affairs. If that person is not performing the duties and requirements that are required by law, or that good common sense would dictate, then yes, they could go to the probate judge, ask or request for a hearing, bring the concerns to the court, and let the court determine what should transpire.
Sometimes, David, you'll hear about representatives of the estates who will be squandering assets, embezzling money, using it for their own personal advantages and things like that, which are highly inappropriate and could easily get you removed. And before you get to the removal process, Jerry, can you talk a little bit about the qualification process to serve as an administrator or as an administratrix of an estate in terms of what you have to do to qualify for that position?
Sure. Generally, you have to be an adult of sound mind and living in the state of Alabama. And that's the three basic requirements. Typically, there are, in the statutes, there are provisions for who has priority of service, and that gets quite complicated pretty quick. Just suffice it to say that there is a lineage, there is a order of precedent of who should serve in priority. But the general requirements would be that is a person residing and lives in Alabama over the age of 18 and of sound mind. Typically in a state situation, we all know that you have a family member that will serve at some level, typical. Sometimes attorneys serve as administrators or administratrix of estates. If there's no family member in the state, for example, then an attorney can be appointed to serve. And it's still under the same provisions, rules and duties of the court and under the court's jurisdiction, attorney or not.
Okay. Another question we've got here. My mother died but did not have a will. I have 5 brothers and sisters. What happens to my mother's house and other property?
It goes back to the prior question. It's what is in the deed. That would be the first thing that I would look at. If there's no will, then you're going to go to open an intestate estate administration where someone is appointed to administer the estate and to look at the real estate and to decide in the estate who is entitled to receive the property. A deed would come out of the estate, transferring that property to the rightful owner from the administrator of the estate.
Okay. And expanding upon that topic a little bit, you mentioned earlier about dying with or without a will. What are the advantages, or I guess disadvantages really, with not doing a will, and basically you have the will of the state as you described it earlier, and kind of tell us a little bit about that process of distribution.
That's the intestate administration, when you don't make your own will and the state determines how much and who gets what, basically. The distribution of the estate assets are determined by preset delineation in the code as to who is entitled to receive what benefit. In order priority of spouses, then children, then you go to your parents, grandparents, uncles, aunts, and then to nieces and nephews primarily.
All right, let's take another break, our final break of the evening. As we head that way, a reminder of how you can join the conversation. Got one more entire segment for you to hop on board here. You can call, text, email. Also find the firm of Hollis Wright. If you search that term on Facebook and on Twitter, it is Hollis_Wright. One more segment of The Attorneys coming right up.
I'm Josh Firth with the law firm of Hollis Wright. Most of us have either been involved in or we know someone who's been involved in an automobile accident. Sometimes the police will issue a ticket if one party is at fault. But what about those times when a ticket is not given? In tonight's Legal 411, we're answering the question, who is responsible when no ticket is issued? Just because there is no ticket does not mean there is no liability, especially if someone is injured in the crash. First, it's important to understand the law. Did you know that unless an officer personally sees the crash, he can't write a ticket even if he is certain the other person is at fault? There are 2 exceptions to this rule. 1, if someone is driving under the influence, and 2, if someone doesn't have proof of insurance for their vehicle. Even if a ticket is issued, that is not a guarantee of liability or that the injured party will win the case in front of a jury. However, a jury may find a person liable for negligence if the person at fault was driving improperly or violated one of these 6 rules of the road. For example, driving without proper taillights, texting or talking on the phone, improper lights or signals on a trailer, failure to yield to oncoming traffic, hitting another car from behind, or changing lanes improperly or without signaling. Any of these can serve as a basis for a jury to find someone negligent for causing an accident and injuring another person or their property. So the person who caused the accident is ultimately responsible for the injuries, even if the police officer does not assign fault. But you have to prove liability. That's why it's so important to ask for legal guidance if you are ever injured in a crash. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer the questions you face on real issues every day. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thank you for watching The Attorneys on Alabama's 13.
Welcome back into our final segment of The Attorneys. Time is of essence. If you want to join our conversation, you better go ahead and get on the phone. Call, text, email. Let us know your question. We'll pass it along if we have time to the panel of experts and our legal experts here. A question that we've got for you guys. What if I would like to include gifts to charity or my church in my will?
That's done all the time. You can do specific amounts, dollar amounts. You can do specific property. You can do a percentage of your estate, or pass after you've made other distributions or provided for your family members, give the residual of your estate in a charitable residual clause in the will.
Okay. All right.
Jerry, we oftentimes hear of stories where sort of in the 11th hour, maybe a child, to the detriment of his other siblings, will go in when a parent, father, mother are on their deathbed and have them execute a new will that they intend to supersede all prior wills, and perhaps in a situation where the father or mother really are not competent to sign the will at that point in time. What then, when that happens, do the other heirs, what are their options in terms of challenging that will, and what do they kind of...
That gets real complicated really quick. Basically, you are looking at a potential litigation matter in worst case scenario. It does occur. I don't see it that frequent or that often. You're going to have to look at the mental competency of the person who made the will. You're going to have to look at the influence of the person who owned the testator, the person who made the will. We have a saying, it's called undue influence. They cannot give or exert undue influence over that person and take away their voluntary choice of what they want to happen with their property. It gets down to capacity to make a will. Is that person competent at that point in time to voluntarily and with mental competence decide what and determine what they want done with their property? If you're on the other side of it and you want to challenge that, then you're going to need an attorney. That's the short answer. You're going to need medical records, you're going to need witness statements, you're going to need persons who were present when comments were made or discussions were had. If the person who changed their will has a series of prior wills, which generally follow a certain format, and then there's a drastic change, that's always a telltale sign. Again, if the attorneys were involved in drafting the prior wills, those folks, those prior attorneys can also be witnesses as to the testator's intent. Generally, you're going to know if someone is losing mental capacity to make a will. It's not easily done by a person who's not a medical professional. So that's when it gets complicated. Back to the first point.
Well, and you had a grin on your face when you said that you're going to need to hire a lawyer, because it's been my experience that in those situations it gets really nasty, really heated, and really litigious fast between the family members, and it's not a very pleasant experience for anyone.
It can get that way very quickly. That's true.
Yeah, and you've probably been a part of that in the past, maybe, or have you been able to stay away from it?
It's, you know, it's a landmine, land filled with mines, I should say. You have to be very careful where you step and how you proceed. I believe in, you know, end of the day, is the person making the will, was that their final wish or not? And that's, to me, that's the real question. the person wins every time, and they get the benefit of the doubt as to what they wanted to do, but at the same time, if it's truly something that's out of the ordinary, you're going to know it.
And we've talked a little bit about the rights and responsibilities, really more so the responsibilities of the executor or the administrator of the estate. And oftentimes, if you have a lot of assets that need to be transferred or disposed of through the probating process, it can be a tremendous undertaking by the representative of the estate. On the flip side of that, is the representative entitled to any fees for the work that they performed in being the representative of the estate under Alabama law, and if so, what are they entitled to?
The general rule is that an appointed administrator, typically not a family member, would be entitled to percentages of the monies that are collected and the monies that are dispersed through the estate. Generally 2.5% of what comes in and 2.5% that goes out. A lot of times you don't see that unless you have a professional administrator involved. A family member typically, will do that. That's outside of the will context. That's an intestate administration. But executor, executrix typically serve without pay through the will process.
A question we've got here. I want to leave my grandchild, who is now 2 years old, something in my will. Can I instruct that he only gets the money after he reaches a certain age? And how do I make sure the money is not spent before he reaches the age of 21?
That's real easy. There are trusts out there. People have heard the word trust through their lives. A will can have what is called a testamentary trust, a trust that does not come into existence until that will is probated. It's brought to probate court and a formal administration is opened. Through that process, in your will, you can make specific bequests to minors who are living and say at what age they get those funds. Right. It's that simple. Compared to that, or contrasted to that, is what we would call an inter vivos trust, which is a living trust, which you can do today and give your grandchildren money today and still put restrictions on it when it is distributed to them.
Right. And David, in the context of our practice at Hollis Wright Law Firm, in handling wrongful death actions where somebody dies as a result of an accident that is the fault of somebody else or perhaps a company, something along those lines. A lot of people don't understand this, but even if you have a will, the person that died in the accident had a will that indicated how he wanted or she wanted their assets distributed, death proceeds from a wrongful death case are not going to pass through the estate. They automatically pass outside of the estate as if you died without a will. Okay.
Hey, we just have less than 2 minutes now remaining in the show, but I want to give both of you guys a chance just for a final thought. And Jerry, we'll start with you. Just a final thought on this subject, things you want to be sure that our viewers walk away with.
I think a lot of folks are confused about what happens with life insurance. Life insurance is a contract you have with a life insurance company. You designate a beneficiary of that contract. If you designate a person, not your estate, then that passes outside of the estate. A lot of folks don't realize that as well.
Okay. And David, I think one or two things that we learned here tonight is that getting a will drafted is not a terribly expensive endeavor. You can do it pretty easily. You can get to a lawyer like Jerry, and he can put together a will pretty easily. Doesn't have to be that complicated, and I think it's certainly a good idea to have that done to get your ducks in a row before the time comes where we all pass.
Absolutely, take a lot of the stress out of your life if you can do that. Appreciate both of you all being with us. Some great stuff tonight. Hope you have enjoyed it as well. As we wrap things up, want to let you know how you can continue to get in touch with the firm of Hollis Wright. Call, text, email them. They return every single call, text, and email. So put them to the test. Also find them on Facebook and Twitter. Appreciate the time. We'll look for you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis Wright.